Welcome everyone to part one of the Legacy Family Business series here at the Institute for Family Business. I am Dr. Fernando Parra, and I have the great privilege of serving as an associate professor of accountancy at the Craig School of Business. I'm also privileged to serve as the director of the Institute for Family Business. This center is dedicated to providing resources to family business like yours. And we provide a safe forum where people can network with each other and identify solutions to common issues in family business. More importantly, this serves as a nexus between your family businesses and the students, our talent, our most precious talent here at Fresno State. Speaking of students, I hope you were able to identify and connect with our students today. We are boldly educating them to help advance the legacy of your family business to the next level. They are the next generation of business leaders, so let's recognize them today for driving our inspiration. If I have students, can you please rise just so that we can recognize you, please? Thank you. Don't be shy. I also want to take this opportunity to recognize the advisory board members who share their invaluable time to guide the center's resources and actions. We would not be able to do their work without their financial support. So thank you, Sam Guile, chair of the advisory board. We're also joined by advisory board member Robert Katka. So if you would please rise so we can recognize you. Thank you. And our very special thanks to Dean Julie Olson Buchanan, who has been instrumental in supporting our center as the first female dean in the history of the Craig School of Business and a great visionary. She is leading our school into our more impactful future. Let me give you some statistics about our family business community. Family business makes the majority of the economic activity here in the Central Valley, from farms to corner stores to those taco places that we talked about outside of this room. We bring family values in our business interactions. In fact, in a recent study that my colleagues and I conducted on family business motivations, we confirmed that family business in our Central Valley drives strong socioeconomic wealth from their businesses. What does that mean? That's academic talk for we have pride in our family business. And our business decisions are not always about the bottom line. They're not always about money, but they are also about the prosperity of our family, the prosperity of the community we represent. When I was a kid, I used to work in our family business, so I understand the commitment you have to our community and why it is a great privilege for me to champion the work that you do. And I'm working diligently on expanding our mission of serving as a networking and resource center, creating more synergies between Fresno State centers, such as the Women Entrepreneur Center, who is co-hosting this event with us today, our faculty, students, and our family business community. One important driving force in our family business has always been women. Let me ask how many women in the audience are here today in business. So thank you for being here today, and thank you for the work that you do in our family business. It is with great pleasure that we partner with the Central Valley Women Entrepreneur Center at Fresno State to provide this seminar. And I am delighted to introduce you to the WEX director, Ana Alfaro, a terrific partner, a champion of women and women entrepreneurs here at Fresno State. Ana, if I may introduce you, has dedicated her career to the field of entrepreneurship in Fresno. She brings over a decade of valuable marketing management experience, and she has served in marketing positions for diverse industries for regional Latin American companies. She has been instrumental in leading the Central Valley Women's Entrepreneur Center since its inception, playing a pivotal role in supporting the Central Valley community of women entrepreneurs. Some of those are here today with us. So please join me, Ana.
Thank you very much for the kind introduction, Dr. Fernando Parra, and thank you, ladies and gentlemen, for being here with us today. For me, it's a deeply honor to be part of Fresno State and, of course, being part of the Central Valley Women's Entrepreneur Center. We have embarked on this journey in the fall of 2022 because we have just launched this program by the Office of Community and Economic Development of Fresno State Foundation, and marking 1 year of dedicated service to the 11 counties spanning from Stanislaus to Tulare in the Central Valley. As with any new adventure, we encountered some challenges, but we have been incredibly fortunate to have the unwavering support of our community, which has placed their trust in us. Over this past year, we have been the privilege of assisting 820 unique clients with technical assistance and thousands of people taking our trainings. 77% of them being women and more and other genders, of course. We also want to extend an appreciation to some of our partners who have been instrumental in our success. Victor Briviesca from SBA, for example. Also, Dr. Parra from Craig School of Business at Fresno State. Bill and Mariana, lawyers of the New Business Community Law Clinic, NBCLC, have played important roles in the overall progress of this center. Their support has been invaluable, and we look forward to continue this impactful journey together. Being an entrepreneur is challenging endeavor for everyone, but especially for women who face additional challenges such as access to capital, networking and mentorship, work-life balance, industry segregation, access to education and training, confidence, and other factors. Regardless of those challenges, in 2018, women business owners own over 12 million businesses and employed over 10.1 million workers. The Central Valley Women's Entrepreneur Center is committed to continue assisting and empowering women and other genders to start a business or expand an existing one. Finally, I want to highlight that all our technical assistance and training have not cost to the community, thanks to SBA, that plays a vital role by providing a significant portion of the funds essential for our operations in the Central Valley. Thank you very much for being.
I also want to thank Victor Vibriesca, who is the Economic Development Director at the SBA Fresno District Office. And if I got the title wrong, please correct me, Victor. Victor has been working in economic development for over 15 years, helping small businesses. And he provides assistance to rural communities and cities to create, develop, and implement strategic plans for the economic growth and tax base of the community. So we appreciate the SBA for powering Fresno State's Women Entrepreneur Center and for providing the translation services for today's event. I'm also delighted to introduce our main speaker of the day, Mariana Acevedo Nuevo, who is a clinical supervising attorney in the New Business Community Law Clinic at UC Berkeley. With prior experiences as the Shriver housing attorney at Legal Access Alameda, she advocated for housing rights among low-income residents in Alameda County. Mariana's journey also encompasses advocating for clients before the Mexican Economic Competition Commission and working in the Market Investigations Unit at the Federal Economic Competition Commission. With an LL.M. from Berkeley Law and a master's in public policy and public administration from CIDE, Mariana skillfully merges legal expertise and societal benefit. So please help me welcome Mariana Acevedo Nuevo.
It's incredible for us to be here. With me, I have 4 students from UC Berkeley. They are 12 in our school. They are really happy to be here. So the first one of our students, Erika.
Hi everybody, my name is Erica Mitsuo from Berkeley. And so basically when people start businesses, you can totally just start without having done anything legal, doing any paperwork, and start your business off that way. That is totally valid. You can just start your business, start taking orders, start providing services. You might have registered with a county or a city doing business as using the DBA, or you might not have. But when you just start a business off like that on your own, there may be some legal risks that you are taking from that. So we're going to be discussing the different types of entities today a little bit, focusing on the LLCs and corporations. So a couple of things up here. Forming an entity can help you shield you from lawsuits. We'll talk a little bit more about that, what limited liability means, help you access loans and investments where banks generally want to fund entities that are incorporated in some sense, and also providing credibility to your business and other requirements for independent contractors in terms of what that might look like for your business if you're hiring an employee or independent contractor. Limited liability is really important. It separates your personal assets from the assets of the business. So generally, if you're doing anything risky, for example, consumption of food or other kinds of things, providing a service in particular, you want to have that legal separation, and limited liability can help provide that protection for your personal assets. So if you don't form an entity, make sure you have liability insurance for yourself. Otherwise, if damages are really high, you will be personally gone after for everything that you own, possibly. So forming a legal entity gives you a lot of power and tells the world what is going on with your particular business. So it can establish clear ownership and management, figuring out who owns what in the business. Is it you personally? Is it the business? Who owns intellectual property? If you have trade secrets, recipes. Also allows for distribution of grants if you have stocks, dividends, stuff like that, and more complex things. And then here we have a point that says starts the clock for economic basis in the stock price. Basically, it's just kind of tax implications, and when you're selling stocks like that, just something to keep in mind. And also, like I said earlier, when you enter into contracts with other providers, it does help to have that entity already established. So there are a good couple of options that you can choose from here. And then next slide. So we have a couple of entities up here. Sole proprietorship, basically when you just start your own business on your own, this would be what you would be falling under. If you are with a partner with someone else who is not your married spouse, that could be a partnership, and you have to realize as well that those two do not have limited liability. So all the liability falls on you if you do not have that shield between you. So these are automatic. Doesn't matter if you do anything at all, you will be considered a sole proprietor or a partnership. And then we have corporations and limited liability companies. So we have a couple of factors to discuss when we are discussing how you choose an entity and what type. We will highlight each one as we go through. So we have tax, governance, liability, capital, and citizenship. So we will go through these one by one, just give you a generic overview of what each of these mean as we move forward. Okay, so first up, we're gonna look at tax. There are generally two tax structures when it comes to an entity. There is double taxation or pass-through taxation. Double taxation is when it is taxed at the entity level. So the entity reports its own income and pays taxes on that. Then you get your own profits from that at dividends, and then you pay out the tax for that. So that is twice, once at entity and once at the ownership level. Pass-through taxation, the entity is not on the hook for its income. It all flows through the entity down to you. So gains and losses go down to you personally, and then you pay taxes only once. So that is why it's double taxation versus just pass-through taxation through the entity down to you.
Hello, everyone. I'm Alfred, also from Berkeley Law, and I'll be introducing governance and liability. So governance, basically, this is the idea of who is going to run the show of the company. And since Erica has introduced all different kinds of entities, to you guys, from sole proprietorship all the way to corporation. And now we're gonna focus on two most common, like corporation and LLC. Those are the most common entities if you are running a business, when you're running a business. And if you're running a corporation, the board forming by board members, which is called the board of directors, they will be running the show of the company. And they will be making a collective decision altogether. That's usually the case in corporations. And they are usually, like all those big companies, they are usually in this kind of legal entity. The other kind is the LLC. This one is also has limited liabilities, same as corporation. They both have limited liabilities. In LLC, it's either the members, which means all members of the LLC, or the managers appointed by the LLC members who will be running the show. Okay, next slide, thank you. But like really try to remember this, very important. Great power comes great responsibility. That means if you are running the show, prepare to take responsibility, okay? You make decision, you take responsibilities. And there's this term called fiduciary duties. This is a legal term. But basically what it means is that when you are making the decision, you have to make the decision in the best interest of owners of the company. If it's an LLC, it's the members. If it's a corporation, it will be the shareholders. Okay? You cannot make decision in the best interest of yourself or all the other people. You have to make decisions in the best interest of owners, real owners of the companies. Next, liability. I think Erica has already given you a really clear picture of what limited liability is. This means, so I'll just go over it again. This means your entity, okay, is either a corporation or an LLC, has some properties, has some rights, has some money. And you yourself, also an entity, also has some rights, properties, okay, or money. And you want to separate them, right? When you're running a business, your business will be taking on debts, will be making money, will be taking on debts, will be doing all sorts of business operation activities. But those business operation, you want it separated from your personal properties. So in case your business goes south, unfortunately goes south, God forbid, all of your personal properties will be safe. That's the general idea of limited liability. And you want that. So this is just a very descriptive way of saying what's limited liability. But bear in mind, there are 4 exceptions to, okay? But this, please remember, this list is not just a very generic review of the exceptions, but please remember these 4 exceptions. The first one is if you yourself personally guarantee something that your business does, okay? If you personally guarantee what your business does, that means you're jumping in, right? Then you wouldn't be shielded. You wouldn't be shielded from the personal limited liability, this concept of law. And the second one is taxes. You are the owner of the business. That means you will be held responsible for all the liabilities of taxes of your company. So pay your taxes. It's very important. Okay, one of the exceptions. And the rest too, I would say they fall under the same concept, which is if you intentionally do something wrong. Okay, say you intentionally hire someone that is doing some criminal activities when he or she is helping your business, then you will also be liable because you intentionally hired this person. Okay? Another case is that if you are negligent, this is also a legal term, which means like you're reckless. Okay, you're reckless in doing things. In this case, you will also be held liable for your business liabilities, debts, that kind of responsibilities. Okay, my part is up. Thank you.
So now we're gonna deal with money, which is, I'm sure, a central part of you guys' business. So where to get it? I feel like we can all, you know better where to get your money than I do. But what I will say is people who give you money, people who invest in your company, will care about the type of entity that you choose. So what we hope to take from this, like what we hope that you take from this, is the fact that the type of entity that you choose to form will limit your ability to ask for money from certain people. So the key questions to begin with: how much capital do you need? If you're aiming to become the next Facebook, then we're talking about different entities that if you're just trying to start a restaurant chain here in Fresno. The second thing would be then whom should you target? Are you looking for institutional investors? Some institutional investors will never go for an LLC just because they cannot. Like pension funds cannot invest in an LLC. So there goes a lot of money. And then sort of just what instrument should you use to regulate your relationship with whoever you're trying to get money from. A lot of these documents, you can make an appointment with us and we can help you get them set up. Our appointments are free, so I'm not selling my services to you. So here are the types, very broadly, here are the types of things that limited liabilities and corporations can get. I would say that the main difference is that LLCs will never get venture capital, just that's how it is. So again, aiming to be the next Uber, are you planning the next Uber for boats? Then an LLC is not what you're looking for. And the other thing is, a lot of people always ask me like, why is my accountant always advising me on forming an S corporation? I'm sure that Fernando will be like, yeah, form an S corporation, save on taxes, whatever. But if you're not a citizen, or if you're planning on corporate investors, then you cannot legally be an S corporation. So those are the two things that I want you to take from this slide. So, yeah, it is very important. This I pretty much covered it. I guess I jumped my own gun. But just to say, some entities cannot invest in certain types of businesses. So, yeah, I can spare you the boring details. So, every type of money that you take will come with like pros and cons, of course. That's everywhere in life. That's what you get. Funds from you, obviously, the good thing is that you don't need to pay back. You don't need to pay yourself back. But you can bankrupt yourself also. So that's the obvious. Debt in the form of equity will always come with like, if I am giving you money to start a business, then I want a share of it. Then I want decision-making powers. And that is some of what I want to get through today. We will cover the foundational documents that you need to start like a corporation or an LLC. And in those documents, people will want to see their rights reflected, right? If you're drafting an operating agreement, if you're drafting your bylaws, people will want to say like, if we're making decisions about selling our shares, then I want something that's called the right of first refusal. What does that mean? So if we are sort of like me, my cousin, my sister, and my mom, and we're all starting a company together, and suddenly my cousin, she's quite problematic, she wants out. What I want written in that operating agreement for our LLC is that we, the rest of the shareholders, have the right of first refusal. What does that mean? It means that you have to offer me your shares first, and then after I say no, you can offer to someone outside of this really tiny group. Why do I want that? I don't want to run your with your friend from work. I started this business with my cousin. I don't want a stranger here. So that will also limit, just when you start an LLC, that also sort of limits the way in which you should think about your business partners. As I always tell my clients, everyone knows who they marry, no one knows who they're divorcing. The same logic applies to business partners. Because when everyone is starting, everyone's really excited, we're gonna be the biggest restaurant in Fresno, whatever. And then halfway through, it's you never show up to work, I'm always covering your shifts, you're always inviting your friends and they never pay. Those types of things occur all the time. These are the stories that I hear every day. So when you're starting your business, you want your operating agreement to reflect, to have some securities for you, to sort of say, oh, this is the amount of work that you have to put in to be considered a member. If you're starting a corporation, this is sort of you don't get your stock all at once. Your stock has to vest. It has to vest through time. You have to sort of earn your shares. And those are a little bit like protections for bad business partners, which could always happen.
Mariana, I'm sorry. So going to the vesting, because I know that's important in family businesses, right? The vesting period of some shares.
Yeah.
Meaning you have the right to actually own the company. So who owns the company as all the partners are vesting?
Yeah, so the thing is, you will have to update something that's called a cap table. A cap table will have the shares that have been issued, and as they vest, these vestings, there's such a thing called a vesting schedule. But those shares are yours. You have those stock options. So that says you have that option to get that stock. So no one else can get it. So it's you have dibs on that. But you actually, for tax purposes, you can choose to, let me go step by step. So there's a cap table, you have a couple of columns, and in that columns you said these are the amount of stocks that have already been issued. These are the people who own it. So that's written down. But then they're subjected to a vesting schedule. If you do not, if you do not fulfill your commitments in order to get your fully vested stock, then those options go back to the pool, sort of return to the corporation, as to say. And then those options can be offered or sold to someone else, to the next employee, to whatever. For tax purposes, there is such a thing that is called 83B election, which is for people who have stock and that stock is subject to vesting. They choose to have all of their tax consequences right at the beginning. Why? Because at the beginning, the shares are supposedly worth less. So my tax consequences will be less. So I buy this share for $1, whereas if I buy this share 5 years down the line and we're already Facebook, my shares will be super pricey and I will have to pay the taxes at the time my stock is vesting. So what you need to know is you need a cap table. That cap table needs to be completely filled out with all of the details of your vesting schedule. The options that are offered to you cannot be offered to someone else. So it's not I sort of have a vesting schedule and someone cut across me and then now they have my stock. No, that stock is yours and you can choose to pay your taxes on it on the first day. But it's not fully yours until it's vested. This is one of those legal fictions that only exist to make, sense of the crazy things that go on in corporate America. But that is mostly what happens. Just there's a cap table, you have a vesting schedule, every year or every month, I will vest 1% more of the shares that I own. And one important consideration is that that's why people emit so much stock. Instead of saying, I will have 100 shares, people go out and say, there's 10 million shares. Why? Because they want everyone to sort of be able to compute their 4% into 4,000 shares, because there's 10 million of it. So that's how you split something in very, very tiny pieces, and people still think like, oh, I'm getting 4,000 shares. Yes, but from like 100 million, so that's nothing still. But that's how they make it sound like a lot. That's like when we see founders or people who are going to for Facebook or for Google, they have like their stock options, and they're like, oh, it's like 5,000 shares. And like, yeah, from what's the pool? What's the size of that? And it's often a lot. And we want to recommend people to always, if you're going out to get money, issue a lot of stock from the beginning. Otherwise, you will have to ask later on people to split their shares to sort of make room for the newcomers. So that's why people go out and issue 100 million stock and say, dude, you own a chain of restaurants. Yeah, but I want money. I want to become the next McDonald's. So that's why I'm starting out with 100 million. Is that?
Thank you.
And we can also set you up with a cap table. There's a lot of services that do it also. So from 50 miles up in the air, what you want to see is, if you're going to go for venture capital, you have to go for a Delaware C corporation. Why? Because what we're hearing from people in the startup space is that venture capitalists do not want any risks. They want to know what they are getting for their money, and that is a Delaware C corporation, nothing else. If you want investment and you don't want to just be stuck with your cousin and your aunt, you probably want to go for a corporation because you want those tiny things that you can share and you can divide. But we would recommend forming in California, because if you form in California and your business is in California and you're operating in California, you're gonna have to comply with California law, and then you're also gonna have to comply with Delaware law if you formed over there. And then if you're sort of looking for an easy entity to set up and it's just like a family business and you don't want anyone coming in, I would say set up an LLC. Fernando probably has another vision because he's an accountant, and accountants are all about taxes. So I think that sort of come somewhere between us, like in the middle ground. And this is just a recap, okay? So these are the three most sort of common options. And again, in a corporation, the board will make the decisions. Sort of the buck stops with them. They can hire a CEO, they can hire a CTO, they can hire whoever. They can bring in Mark Zuckerberg to run that place. If there's a mistake, if they fail to sort of comply with whatever duty they have to, the buck stops with the board. It is good because then you have a lot of people making decisions, right? One piece of advice that I will share with people is, let's say you're starting a business with your friend. He has a ton of money, but he's not the brightest bulb. Don't give out, seats at the board table immediately just because this person is here at the beginning. It will be way harder to remove that person from the board than to never see him there in the first place. So if someone is just coming in with money, they can be shareholders, that's fine. They just don't have to have a seat in the board. If you can swing it, don't see people there that you don't want sitting there. Because, sí, Fernando.
So how do you structure that in the operating agreement so that you're not granting everybody a place at the governing board? Is that part of the OA, or is that?
That's actually will go in the bylaws, but that's like the board you have to choose. So everyone will be a shareholder. Everyone will have shares. Everyone will have like that precious stock to put in the table. Some of you might even be shareholders for Apple, but Apple is not here asking you for your opinion on however they're running the business. So just you have to understand that shareholder and board member is not the same. The board gets elected by the shareholders, but you can sort of tell your cousin hey, this is a lot of work. I know you have other things going on. Let's just structure the bylaws in a way where you're not forcibly sitting in the board. We don't want to tie up your time like that or something. Just set it up politically in a way that makes sense for you down the line. Because what we hear from a lot is well, this person is in the board, but he doesn't know anything about the business. And in our annual meetings, he's just dragging things, and he's just he doesn't know it. Yeah, he just doesn't know anything about the business. And you don't want people like that in your board. And you don't have to have them. You just have to give them shares. If you are getting money for your company, you have to give them equity in the form of shares, but you do not have to give them a seat in the board. A lot of people, particularly more knowledgeable investors, will be like, of course I want a seat in the board. What, sorry? Yeah.
Do you recommend voting and not voting shares in this scenario?
Yeah, okay, this is more like a deep dive, but there's a type of thing that's called preferred stock and general stock. And then there's also founder stock, but let's stay with preferred and general. So you can issue two types of things. There's voting shares and people who get their economic rights paid at the beginning. So let's say your company is going south fast. Some people will get their money first and have a voting power over the corporation, and some people just get like general stock, which is no voting, sometimes no voting power, and sometimes also they get paid, towards later than the preferred stock. Again, this is how you set up your corporation. We haven't yet gotten to that. Our friend Josh will get into the weeds of that. But yeah, you can set up your corporation. You have some liberties to set up your corporation. The only thing you cannot do is limit the fiduciary duties of the board. You have some leniency in the LLCs, but in the corporation, you cannot just say, oh, you people don't have a vote, and also we don't have to be accountable to you. You can do whatever. There's some limits into what you can write down in your values. But other than that, I feel like it's pretty lenient, and you can get away with a lot. Setting up in your values and the type of stock you choose to issue. Yeah, in the LLC, there's two types of governance, is members and managers. If you set up an LLC, you can choose to manage that LLC yourself as a member, or you can choose to delegate that task to a manager that you pay. Someone like a CEO, you can have a CEO in an LLC, you can have whatever you want in an LLC. But then, the members have to agree in which manager is taking, control of how the day-to-day operations will be run. And again, the only other thing that I'll say is that in the S corporation, everyone has to be a citizen or a legal resident, including partners. So if you are married to, like I am, like my partner, I am a Mexican, he could not be in an S corporation because I am a Mexican and I'm not a legal permanent resident. So then he would not be able to be a part of an S corporation. Also, companies, institutional investors will not be able to be a part of an S corporation. And then the last thing is like where to form. I think we already covered this. The two main choices in our opinion is California or Delaware. Some companies have to go to Delaware, that's just how it is. But most people will just be better served by staying in California because then you only have to comply with the rules here. And then, yeah, someone else, Kevin will start with the LLC, how to set it up, the formation documents, etc.
Thank you, Mariana. Hello, everyone. I'm Kevin from Berkeley Law, and I'm going to tell you guys how to set up an LLC and what's its advantage, its disadvantages, things like that. First of all, let's go through how can we form an LLC. First, you can just register it online and pay $70, and then finish an operating agreement. Then you can form an LLC. It's easy. So how do you to do an operating agreement? There are three things you have to do. First one, agreement does not need to be in writing. It means that you can do it in oral, but you record it. It also can be an operating agreement. And the second thing is that it doesn't really have to be operating agreement, the name. And the third thing is that it has to be entered into by all the members of LLC. All of your partners have to be in the operating agreement. Yeah. So what terms should be in the LLC operating agreements? There are like 3 things you have to put in it. One is management, is that who is going to manage? How about the shares? And contributions and distributions. These are the 2 things might get some misunderstanding. We'll put it in the next slide. And having a written operating agreement is really recommended because, well, something bad happens, you always want a paper thing to prove that you have agreement on this before. So we will like suggest you to use a written operating agreement. And if you want more information, you can just, Google it. Yeah. Yeah. Okay. Okay. So let's talk about contributions and distributions. The most different thing is that contribution is more like when you're starting a company and you start to put money into it. It's for your own contribution, and your money goes into your company's the capital's account. And if you're doing the distribution, it's more like you're like sponsoring your own company. It will goes into your company's profit. It will goes into the income amount, income account. Sorry. So in the operating agreement, we will we will have agreements about contributions and distributions. Yeah. So it is quite lousy, but easily. Yeah. So what's the advantage of an LLC? LLC, just as we said, it provides a limited liability to you because the liability goes to a company, that doesn't go to you. And the second thing is that LLC is easy to take on capitals. It can also acquire debt. It means that your company, you can have your credit card, you can get loans from the bank, but it is from the company, but not from you. And the third thing is that you will have some tax breaks from the LLC. And the fourth thing is that it is easier for LLC to get contractor jobs. For example, if your LLC is like you're providing janitors to other companies to do their jobs. If under California law, if the janitor is not under a company, it cannot be seen as an independent contractor. And if they work for a company, and the company will think, well, you're my employee, so maybe the company won't let the janitor go to their company to work. So we will strongly recommend that if you're like a company like this, you are like providing like janitors to companies to work, maybe you will need an LLC. And the fifth one is that actually forming an LLC doesn't need SSN. So it is, even if you're undocumented, the LLC will also allow you to legally earn profits. And the sixth thing that LLC is easy to change. You can sell it, you can convert it into a corporation or to dissolve it. It's easy. All right, so what's the disadvantages? The disadvantages is like you have to pay for like $800 a year for an annual minimum franchise tax, and LLC also needs to pay another tax called gross receipt tax if you're earning too much, and LLC cannot be used for business that require a license, such if you are like real estate broker, if you do tattoos. And like all LLC comes pass through to the owners. You can't hold back. Like you earn the money from others, but you cannot hold back to yourself. You have to pass through the company, then you can get that money. So that's the disadvantages. And for LLC, like the laws doesn't make venture capitals or like institutional investors to use, so you cannot gain money from them. So the last one, the disadvantages is that it is not easy to sell your interest in LLC. If you want to like sell it to others, you want to get out of the LLC, but actually because LLC is quite a private company, so the numbers are sometimes not public and sometimes you can get bluffed. So there are like that's a less market for you to sell your interest. So the last thing to tell in the operating agreement is management. Like what member consent will be needed. Like if you're going to spend money, do you have to like get agreed by others, things like that, and maybe taking on debt or getting new members? You will love to have it in your operating agreement. and like how much time are members expected to spend in the LLC. If like your members are like just quitting, they don't want to get into the LLC anymore, and they want their contributions back, can they do that? You can put it in your operating agreement. Okay, so like an LLC, you can see that who gets what kind of equity of an LLC. Like first one is the founder, it's you. If you want to form an LLC, most of the time you can get both profit sharing and management right, or you can appoint it to someone. And sometimes your friends and family, they can also sign the operating agreement with you to become an LLC member. But sometimes because they don't know about the company, they will take a passive role, leaving the most management duties to you. And the third one is angel investors. Sometimes there will be people who want to invest you in your LLC, but in the operating agreement, sometimes if like you will have an agreement that if you like earn enough, then you have to pay back to them in terms they invest you. And the fourth guy is venture capitalist. It will not appear in LLC. And at last, it's employees. Actually, if you are an employee of an LLC, actually you don't have any options through the operating agreements through LLC, unless you are like invited to join the management team in the LLC and sign the operating agreements together. Then you can have the rights to manage. Yeah, that's my part. Thank you.
Awesome. So I'll talk a bit about corporations now. So a few things to remember about corporations. The first is that a corporation is a separate legal entity distinct from who you are, which means you could think of a corporation as its own kind of person, and it's separate from you. And so it's got limited liability, which means as long as you follow the rules and you're not reckless, nobody's going to reach into your own personal pockets and take your personal account, money from your personal account. The second thing that Mariana mentioned a little bit is that with corporations, we have really the main governing mechanism here is the board of directors. Corporations have really three stakeholders. You have the shareholders, right, who own the corporation, who own the business. You have the board of directors who kind of oversees the business and who's sort of responsible and answering to the shareholders. And then you've got management, so think CEOs, CFOs, the people that the board kind of oversees, that the board relies on to manage the day-to-day operations. Great, so how do you actually form a corporation? It's really, there's two things that you have to do legally to form a corporation. So the first thing you need to do is essentially file with the Secretary of State. You can do this online, it's just, it'll take 5 minutes. You go to the Secretary of State website, you fill out a little thing called in California, it's called the Articles of Incorporation. It's not a long form at all. You've just got to designate a name for your corporation. You've got to say what the purpose is of the corporation. Generally, you'll keep it broad and use sort of boilerplate language, right? You'll designate, how many shares are going to be issuable in the corporation. So that's the first thing. The second thing is a way more fleshed out, governance document, and that's the bylaws, right? So first, file that certificate of incorporation, and the second is you'll want to draft the bylaws, which is really the rules of how the company is going to run. And so your bylaws are going to go over how are we going to hold the vote, right? How many people need to be here for a valid vote? When are we going to hold our meetings? What's the process behind all of this? And the bylaws are just extremely important because, as Mariana and everybody else said, generally if you follow the rules, you're going to have limited liability. But if you don't follow the rules and you don't follow the process, especially with a corporation, that's when courts and other people can sort of reach into your own pockets and hold you accountable. So it's really important that you have a good set of bylaws. Some of the other things that aren't required, but will be nice to have and are pretty common in startups will be what we call an employee confidential information and inventions assignment agreement. That's a long way of saying a contract that assigns the intellectual property of your employees to the business, right? So like, what does that mean? Like if you own a shoe company and you have, a group of 10 employees who are all designing shoes every day and, these employees, come up with a new shoe idea. What this contract does is basically says any idea that your employees come up with are the company's ideas. And so they can't just come up with something and run away with that and go start their own company. And so this is really important for almost every business because every business is going to have some intellectual property that you'll want to protect, right? So that's something that's nice to have. The next thing, the initial action, that's really just a fancy way of saying, the boards got to essentially get things started, right? Adopt the bylaws, and you can do that via unanimous written consent, which is just another way of saying instead of all meeting physically in one location, all the directors are going to sign a piece of paper that says, hey, we adopt the bylaws for this corporation. The last thing here, Mariana touched on this a little bit, is that restricted stock purchase agreement. So a lot of times what you'll see in startups, right, is somebody has to own it, right? And so it's usually the founders, right? But sometimes the startups, they'll hire employees, right? And as an incentive, those employees will receive some equity or ownership stake in the new startup. But they won't always get it immediately. Sometimes they get it in the future, right? And so that's what sort of the vesting of stock options is. In simple terms, what vesting involves is, we have a startup, we think it's a good idea, there's a few software engineers on our team, but we don't want to give them like 15% equity right now. But what I'll say is, let's wait a year, and if you stay on for 1 year, 2 years, 3 years, you can build up that equity, and we'll actually give you that equity, right? So think of the stock options and all of this vesting stuff as just a way, it is an incentive for employees. Yeah.
So I got a complicated question regarding vesting, and I know this is particularly applicable to spouses, right? So you may use vesting, which is a period of probation, if you will. And sometimes you may want to vest your companies with new spouses, and that happens in the market. I'm not saying this is legal advice that I'm providing, but isn't that something that you see often, Mariana, with partners, spouses, a way to delay granting the whole cake? And if you stay with us, if you give your energy and your blood and your sweat with the company for more than 10 years, then at that time, then you'll be able to enjoy full equity. But if you get divorced, next year from me, then you might not get that. Is that possible?
So normally what happens, so just so you know, this is mostly happening in startups. This is, in Berkeley we have a lot of startups, so this talk sometimes is given to people who do want to be the next Uber. In smaller corporations, what you have, maybe in startups as well, but it's called a buy-sell agreement. In your buy-sell agreement, you can restrict the transfers that could potentially take place and include many things. For example, you can include a clause where it says, if you are going through a divorce, these shares do not go into the pool of things that you get in the divorce. If your spouse needs, in order for the divorce to be fair, then they have to go to your other assets. You cannot give these shares to your spouse. Or if that is going to be the case, then we get the right of first refusal. So instead of them going to your spouse, you first have to sell to us, rather than you going to your spouse. The reason for that is, again, you don't want people you don't know in the business. And also you don't want a disgruntled spouse as your new business partner. So what you do is you get buy-sell agreements with people who are in your corporation. You set it up in an additional document that, again, the term is buy-sell agreement, where you sort of include all of these provisions. You cannot do that if sort of a posteriori. You are now, you didn't set up your bylaws, you didn't do anything, you just started and just rolled with the punches, and then you sort of now have a disgruntled spouse. That would be a terrible time to negotiate that type of clause, because you're already in the midst of it. But you can prepare for that by setting up the right corporate documents, which again, I think I wish I could just tell you, just draft one on your own, let me get you a template, but I think that that's the type of thing that you'd be best served by talking to an attorney about your specific case. But there are certain types of provisions that you can include in these agreements that sort of can protect you from having to be a partner of someone you don't want. There are many things. That's also estate protections. For example, let's say you started a business years ago, but these partners, your partner's kids are not very bright, they got everything handed to them, they're not very smart, you don't want them as your business partners. You can also protect your company from that. And it normally involves a form of a right of first refusal and sort of limitations for how the shares can be transferred, but you need to agree on that. It's not something that it's automatic with the formation of the business. So these are the things that go sort of like, that's why mandatory, bylaws. But you can go right now to some legal, like open up an account, and for $50, get yourself your company formed and get your bylaws. Those bylaws will likely not include these protections for obvious reasons, because they don't know who your partners are, they don't know you personally, they don't know what type of restrictions you want to impose on your stock. So that's the type of thing that you work out with an attorney. And this is my pitch for why attorneys will not be substituted by artificial intelligence. Just because a lot of this involves asking questions to your clients and sort of finding out what type of protections they want. Does that answer your question, Fernando, or what?
Absolutely, and I say because that's often something that creates conflict in a family business. You know, succession planning issues. You know, you lose your spouse, and all of a sudden the children of that spouse, previous children from a previous marriage, are now owners of your company as well, and now they get to make the decision instead of you. Or, you know, you may have partners, as you said, that you started with, which you love, but then you may not have the same confidence on the people that are working with you and their children, right? And so you want to make sure you have those protections, the seller-buyer agreements, and you got to negotiate this up front, right?
Yeah, you have to negotiate that up front, and that has to be a part of your sort of dialogue with your business partner. And if you cannot agree on your buy-sell agreement at the beginning, let me tell you what's going to happen at the end. Like, some people are like, I don't want to get into trouble, I don't want to negotiate this contract. It's like, if you cannot negotiate this contract here, imagine when things get rough. It's going to be way worse. So this is, like, the beginning is the best time to have this. I will just say for my Spanish speakers in Mexico, we have this saying that say, más vale una colorada que mil descoloridas, which means better to have a big fight here than 1,000 small fights over the course of your business relationship. And I think that that's what a buyer-seller agreement sort of provides for. Again, do not recommend to set that one up by yourselves or via some legal, unless some legal or whatever other service, because it's very much contingent on the person that you're working with. Like, you sort of know your partner, you sort of know that his wife is like, that the relationship is already going south. You don't want your company sort of tangled up with someone else's personal life, but you have to plan for that.
Thank you.
Yeah, next one I think is fine. Okay, so what are some of the advantages and disadvantages? So Mariana already talked about one. If something that you're interested in is down the road, if you're interested in institutional investment, so like venture capital investment, the corporation is the way to go. The reason why venture capitalists want to invest in corporations from Delaware is just because that's what they're most familiar with. That's where the most reliable law is, and so it reduces the uncertainty of that investment. Especially in down markets like this, you don't want to give VC investors any reason to hesitate with their investment. So if that's on the horizon for you, or that's one of your goals, it leans in favor of wanting to incorporate, as opposed to an LLC or maybe some other partnership entity. Another thing here is tax matters. So we talked a bit earlier about how corporations are double taxed generally, whereas some of your partnership entities are going to have that flow through taxation where you won't pay as many taxes on its face. But there are some situations where having that double taxation structure with the corporation might actually save you some money, but it really depends on the personal circumstance. Generally, right, the corporate tax rate is going to be a little bit lower than certain income tax rates, and so depending on the extent to which you reinvest profit into your corporation, you actually could save money with the double taxation structure. But it's complicated, and we recommend that you talk to an accountant, depending on your situation. Another thing here is, depending on the role that you want to take in your corporation, right? I mentioned earlier that with corporations, there's that division between ownership and control, right? The shareholders are the one who own the corporation and who enjoy the profits of the corporation. It's the board that's actually sort of managing and overseeing the corporation. And so, with the corporation, what we have is, you don't have to be actively managing everything day to day. You can have your board managing that, who's also overseeing your CEO and your other executive officers. So it gives you a little bit more flexibility in terms of the role that you want to play. Another thing I'll talk about here is preferred stock. So we talked a bit about this earlier. So every corporation, right, has stock, which is just ownership in the corporation. Generally, if you have stock in a corporation, right, you have also voting rights, which means you can vote at the annual meeting. Stock also entitles you to significantly the residual profits of the corporation, right? What preferred stock is it's basically a modified version of stock. So, if you want to bring in a new investor, but you don't want that investor to be able to have voting power, to vote out boards of directors, or you don't want that investor to have certain other powers, or maybe the investor, they want to be paid out before all of the other equity holders, right? If the company liquidates and has to pay out all of its creditors, and then all the residual profits go back to the equity holders, maybe this new investor only wants to invest in your business if they get dibs and they're at the top of the liquidation stack. So preferred stock does that job. Preferred stock is the mechanism. Basically, it's a special customized type of stock that it's a matter of contract. So you write up the contract and say, hey, we're going to give you this amount of shares of preferred stock. Here are the rights that are going to come along with it. And preferred stock is a very popular way to do things in the VC world, just because VC investors, they're taking risks on your business and they want to be paid out first if it doesn't go too well. So it's kind of think of it as a mix between debt and equity. The last thing here for corporations, we talked a little bit about this earlier. So this fiduciary duties don't just apply to corporations. They also apply in LLCs in California. Again, fiduciary duties, think about kind of what we talked about at the beginning, where there's a separation of ownership and control, right? If you own the corporation, but you're not actually controlling the corporation or managing the corporation, you might have concerns over whether or not management's actually doing a good job, right? So like if you go on the public markets and you buy stock in Facebook, right, you literally own part of Facebook, but you don't know, right, whether Zuckerberg and the management team's actually doing a good job. And the way that we correct for that agency problem is through these fiduciary duties, right? Functionally, what does that mean? There's two fiduciary duties, which means if you're a director of a corporation, right, or if you're a partner in or if you're a member in an LLC, it means that you need to act in accordance with two things, right? First, the duty of care, and second, the duty of loyalty. Those are the only two duties that you need to act with. We have some of the statutory language up here. It's kind of complicated, but I think in short, what the duty of care is you can't shirk your responsibilities, right? You can't get lazy and not pay attention to what's going on with your corporation. You've kind of got to know what's going on with your business. You have to know what's going on with the books. You have to review things. You have to be somewhat diligent, right? The language there is, right, an ordinarily prudent person, right? No one actually knows, even lawyers, like we don't know what that actually means. But really what it means is you've just got to kind of be on top of it, and you've got to be, you can't just shirk all of your responsibilities. That's the duty of care. The duty of loyalty here is basically be loyal to the corporation, and whenever you act, the corporation needs to be sort of number one priority, right? And so the duty of loyalty often comes up in situations where there's like conflicts of interest, right? So a very common situation is, imagine you're on the board of a company that sells lemonade, right? Which means you owe fiduciary duties to the shareholders of that lemonade company, right? But imagine you also, not only are you on the board, but you have another company, right? And you grow lemons, right? So you have these two companies, and so there's obviously a conflict of interest here, right? What you're not allowed to do is, say to your lemonade company, hey, let's overpay my own my lemon growing company way above market price, right? Because you own this other company. You're not allowed to do that, right? That's a conflict of interest, and that's what we call self-dealing. You're not allowed to do that. Duty of loyalty, you just have to be loyal to the corporation. You have to be transparent and honest whenever there's an interested transaction is what we call it, right? If you're on the other side of the transaction, you have to be careful. That doesn't mean that you can't engage in interested transactions. It just means that when you do, you have to have the best interests of the corporation at mind, right? Just remember, you're a fiduciary, and so you have responsibility to the shareholders.
So this happens a lot in real estate companies, right? When you create separate entities for each property for protection reasons, and a lot of these transactions are going to be with interested or interrelated with
companies.
Just use the word.
Interrelated parties.
Interested parties, right? So, what is the standard then when everybody is really involved with itself? Like, at what point do you say, well, it is conflicted, but it is
Right.
allowed because we're all in agreement and
Right.
everybody's benefiting from this transaction, right? And we're protecting the whole enterprise.
Yeah, that's a great question. So the question is when there is an interested transaction and there's a lot of conflicts of interest and you're doing deals with entities where you have interests on both sides, what's the standard for that? When is it okay? When is it not okay? So usually the standard is a fairness standard, which essentially means when you do a deal and it's an interested deal, it's got to be like what market price is, right? You basically, you can't give yourself a discount. You can't give yourself like a pro rata. You can't give yourself a disproportionate amount of profit, right? You can't self-deal. So what's going to happen is a court might look at that and be like, well, you signed this contract with your own lemon growing company, and you paid yourself 400% over the market rate, right? It looks like you're using your power in the corporation to benefit yourself elsewhere. So I think the answer to that question is the courts it's a very amorphous standard, right? It's not a hard and fast rule, but the courts are going to look at that and say, is it a fair transaction, right? Because if it's fair, then it's all good. If it's not, then maybe not. But that's my answer. You might have a better one.
And no, excellent.
Thank you.
No, I would just say, obviously, the person who brings the action against you as a board of director are the shareholders. So if the shareholders perceive that you are sort of, for lack of a better word, screwing with them, then they will bring an action against you. The defense on the side of the board will be business judgment. This was a business decision, and it was taken care through reasonable business judgment, reasons, for lack of a better word. If you don't cut up to if you're not fair, if you sort of paid $40 for a single lemon, then obviously you're gonna lose because no business person will ever engage in that transaction. So I think that it's gonna be if the shareholders request to audit your books and you come out lacking, they might bring an action against you. But the person who have to perceive it as fair are shareholders.
Not the government?
No, the government.
So for example, if I set up my intellectual property to be owned by an Irish company which pays less than 15% taxes, and so that's my grandma's recipe, it's owned by a holding company over there.
Yeah.
And every time I make a lemonade, I pay all of my profits to that company.
Fernando, this is cheating because this is bringing stuff to taxes where you know more than me. So I feel like this is inherently a bad deal for me. But there is this tax planning, or in Mexico it's called precios de transferencia, which is interrelated parties give each other prices, and obviously that's a tax. They have in mind if you are losing, then we should pass all of our profits to you because you are bleeding money, and sort of will even out because you are my subsidiary, and then but that's a tax planning strategy, and we don't deal with taxes in this unit. The government will likely not care about what you do with your, they do not audit your books, save for tax reasons, and people who have to perceive it as fair are mostly shareholders. Obviously, if you're defrauding the IRS, the IRS will care, but other than that, and they will get you, yeah. Okay, so I know that most people here are but I want to have more money for my company, for my LLC, for my corporation. How do I bring people in? That is not as straightforward as just going out to the street and being hey, hello, my name is Mariana, I'm starting a company, here's one share or one unit of my LLC. That could be considered in California and federally as issuing securities. Securities laws are really strict in the United States. And you could get into serious trouble if you are offering your stock or units of your LLC out in public. So in California, there is a small business exception. And these are the requirements that you have to meet in order to not need an attorney to offer your units of LLC or your stock. These 4 things. First, it has to be under 35 people. So if you're, I don't know how many people are here, but if I just came out here and tried to pitch you Mariana Simone's, I think it's over 35. I don't know. Fernando, yeah, I don't know. It sort of has, you have to prove that you have a pre-existing relationship with the person, like either business, person, or whatever, which is very easy to prove, because if you meet at a networking event and then you sort of have a pre-existing relationship and you sort of believe me that I met you before. The other thing is the person who's buying your stock or the units of your LLC has to be buying them for themselves. They cannot be buying them to sell to others. They cannot be buying them for using someone else's money, investing someone else's money. And you cannot have offer or sell stock through publications or advertisements. This is the California rule. There is also a federal rule, which is Rule 504, that you can claim this exception as well. If you have to issue stock, it can cost you, it can run up your legal bills a lot, because lawyers who deal with the SEC charge. They charge a lot of money. So be mindful to fall within one of these small business exceptions and seek advice whenever you can. The exception that I spoke about on the previous slide, you're supposed to be able to fill that form by yourself. You don't need an attorney to do that for you. But you have to fall within that exception and you have to meet that criteria. Obviously, we strongly recommend speaking to an attorney, just because that is serious trouble you can get into. Now, I do want to touch on selling businesses in general. So there's two things that I want to say. So say you have an LLC, and your LLC, your primary asset is you have a restaurant and you want to sell it. People will be probably more interested in the physical assets than in the actual business. That's your recipe, that's I'm a Mexican and you are running a Chinese restaurant. Probably I don't want to run a Chinese restaurant because I don't even know how to cook that type of food. I would prefer to bring this to a Mexican. So what I want from you is to, the piece of land that you own, the things that you have in your kitchen that I can reuse, the parking lot, whatever, the physical assets. I don't want your intellectual property, I don't want your management, I don't want, I want to do my own thing. So then it's pretty easy to sell, because what you're selling is physical assets and not a business, and what you need is a real estate broker, right? Someone who has a license to sell your business, and then that's it. But what happens when you're selling a business, not a physical entity? Just you're not only selling, the restaurant, the pans, the pots, the stove, whatever. You're selling your you have franchises, for example. You're selling your name, you're selling your intellectual property, your logo, your recipes. You're maybe even selling, just telling the employees will stay, so you have everything set up. All you have to do is, then it's gonna depend on, you might need to get someone who offers up these businesses, and these people might need a license to offer these businesses. So I cannot just go into some random place and start selling businesses because I don't have the proper license. So someone who sells a business, as an LLC or as a corporation, normally have licenses. And when they are charging you for selling your business, they have to be licensed. So just to recap, what I want you to take from this is, if you're selling your business, the IP, the name, not only the physical location, then you need someone who's licensed, because this person is charging you a fee, and therefore he needs to have a license. If he's charging you a fee and doesn't have a license, this person might be ripping you off. So think about it. And the reason why this is important is because this person is selling securities. He's selling the ownership of a company. So it's what we're talking about. He's offering up your business, and to offer up a business, to sell securities, to issue securities, you need to have a license. Okay. So this is not strictly about forming your business, but it is about family business. So an employee is not anyone under 18 years old. So if you're hiring your son or daughter to wait tables at your business, that is not your employee. This does not include and it makes sense that it does not include that, foster children or stepdaughter or son, because the law is seeking to protect these people, right? It's seeking to protect these children. Otherwise, I will just be like, what's stopping me from getting 12 foster children and not hiring any employees? So think about, that's the backstory of that law. Once your child reaches the age of 18, then he or she becomes your employee. Sí, dale. Si quieres en español. So the question was, can I get my son in my LLC? The answer is yes, but if he's a minor, there will be like an operating agreement is not considered strictly a contract, but there might be restrictions in terms of getting him to be a business partner. So, yeah, no. Sí, yes. He definitely, everyone working for your company should get paid, not your kids, but everyone else. Just like sometimes people are like, oh, I gave this person is my co-founder, he has like 3% of the business, that's why I'm not paying. That's illegal in California. There are no exceptions for founders. Everyone has to be paid minimum wage in California. So if you're thinking of starting a startup, don't come talk to me because that will be my answer. And I always see people just like, but everyone is doing it. And I have to be the wrong person, but that's illegal. Yes, Fernando.
Yeah, just to clarify, so that means they have to be employees, even partners have to be employees if they perform duties within the
LLCs are more lenient,
yeah.
But corporations?
Okay, yeah. But in an LLC, you can have members
Yeah.
that are donating their time as
Donating their time.
Or-
I won't be caught on camera accepting that, no, sorry. No, everyone has to be paid minimum wage. And that's the final answer. It's just, if it's your company, if you're the only person, obviously, like, if you're not making minimum wage, like, what can you do? But if you're sort of like giving someone 4% stake in your LLC, that seems a bit shady, no? Like, you have 4% of this LLC, you have 0 voting rights, and you're not getting paid minimum wage. You see the difference between those two types of founders. So LLC members, if it's your company and you're running it with your husband, wife, son, daughter, whoever, obviously it makes sense, like within reason you can act. But if you're giving someone 3%, Fernando, what does it mean?
Does that mean that you have to actually enroll them as an employee of your company, or do they get just compensation through equity distributions that are up to the minimum wage for that year?
No, you have to enroll them as members of your company. Like as employees.
I see.
Yeah, someone who's an employee has to have all the employee protections.
Question.
¿Te la digo en español?
Sí.
Ok, ¿cuál es el mínimo porcentaje que se le puede dar a un?
The courts are not clear. Las cortes no están claras en eso. O sea,
But you say not that 30%.
no.
What is exactly that minimum?
Las cortes a propósito han sido ambiguas en eso. ¿Por qué? Porque no quieren que la gente lo haga. Entonces, no quieren decirte, a partir de 25%, ya, estás del otro lado.
But what happens if you mistake at that kind of point because you don't have any number and you put a minimum number and it's what's going on with that one? I mean,
So
You're going to
what's
be on the hook for back wages. Vas a deber salarios caídos.
Can we repeat the original question and
Yeah.
for everyone to hear?
So, I'm sorry, I didn't get your name. ¿Cuál es su nombre, señora?
Laura.
Laura was asking me, what's the number? How much ownership stake do they have to have in the LLC for us to not run into this employee-founder problem? The answer is that courts have not been clear on that because they don't want you doing that. They want people to make at least minimum wage. I would say if something is south of 25%, and I don't want to be saying this, so it is a very unclear rule, and it's mostly related to California. Other states don't have this problem, or don't have this protection for employees, depending on which side they're studying on. Yeah.
Something razonable.
But
It's okay, no. It's around 10 and 15 because I hear about for a loans, they say sometimes it's like that 10% or 50%. But I'm very confused because you say no have number, but if it's 10% or 50% one person, but it's not correctly, what's going on? I mean,
es que está usted hablando de préstamos.
No. For the percent for the partner, for the LLC.
It is also going to depend on the number of partners. I see Fernando making a face because this is a very touchy subject and no one likes to hear my answer. It's just like, we have attorneys, obviously maybe people who are not being paid and do not work for a non-profit have more leniency to sort of say, like, this is how you could play it. That's not my case. So I will say everyone has to be making minimum wage. It's going to depend also, like, if your LLC has 100 members and someone owns 10%, then this person is probably not very, like, it's a very big deal within that because there's 100 members and he has 10. So the rest of the members, a lot of the rest of the members would have to ally against him to sort of outvote him. It's gonna be very contingent on that. I don't wanna.
No, and I guess each individual case is important too, so I think that's why it's important for you to meet with an attorney for your specific case in situations like this, because there's not a common rule for everyone, right? And so I think we could follow up on that conversation.
I'm sorry, you had another question, or are you leaving?
I did, and I was going to ask if it depends on the nature of the business. I'm an accountant, and profits, interests are issued for services all the time. And it's not illegal.
No, I understand. I just have to say and be very clear that in the context of corporations in California, everyone, including founders, has to be paid at least minimum wage. Subscription agreements, buy-sell agreements, what we were touching on before. If you're getting someone's spouse to renounce their rights, they have to sign those rights off. Like, remember I said, like, you don't want someone's disgruntled spouse? This person has to sign these rights off. They have to accept that they will not be getting the shares. So if they don't, your buy-sell agreement might not be operable. Also, normally buy-sell agreements preclude transfer of stock to children because children cannot be a party in a contract. And yes, I'm sorry, Fernando, is it to do or to do?
No, it's fine. I'm really interested. There's a lot of questions that come through the center about employment with family. So I would love to see where you were heading with some of the rules on FICA and FUTA, taxes, etc.
Yeah. So normally, people who are under 18, you don't have to pay FICA taxes for your children. And you don't have to withhold your family members' portion of FICA and FUTA taxes either. So you don't have to take it from their whatever it is that you're paying them. I'm sorry. Yeah, that's mostly it. You don't have to withhold taxes for your kids under 18. FICA and FUTA, but you do have to withhold payroll taxes forever.
I am very grateful to you and all the students who did super well. I'm super impressed, by the way. Super impressed.